and I did send a message to your judicial assistant, Mrs. Wilk. Sorry. So the dates are there. The proposed motion hearing dates are also provided to the court.
In the email?
In the email.
Right.
And then deadlines for the state to respond to those dates are also in there. In the original message that I sent. What I haven't had an opportunity to talk to the state that I was able to speak to co-counsel is asking the court for some deadlines from the prosecution in terms of we already have orders from the court for example, an order on a motion to compel from May that we're still waiting for some returns on. So we're asking if the court could now, and again, I did not speak to the state on this issue, so I just raised that to the court's attention. But
my intent, I appreciate y'all getting together. My intent would, I'm going to go back through and go through the docket, see kind of just surface level where y'all are at, and I will do that. We can have another case management hearing at that point about the discovery. That will allow me to set deadlines.
Just for the court's benefit, we're proposing some deadlines for this month on items that the court has already ordered, produced. And
what
then
is the state's position on that?
I haven't seen exactly what defense is talking about.
literally I'm asking the court to issue an order that the previous orders to compel are complied with by the end of this month.
I just need to go into this.
Okay.
What it's for. Obviously, if we had this stuff, it's easy to get. We don't. We're going to have to endeavor to get it.
So, and the other, in the court, and I'll, again, because I haven't put anything in writing, but the issue that we're having is that the court's providing orders, we're not having compliance. So we're asking for deadlines, and they're also going to ask if the court sees there's non-compliance with those deadlines, again, looking to prior orders from the court, that the court would start entertaining counsel's request for a spoliation issue if it is lost, or that the defense would have the option for exclusion, meaning they do provide it, but because they're providing it beyond the deadline, that we'd have that option to have that evidence excluded.
Okay. Why don't, since you are just,
We gotta go.
so I do see the list. I would like to look through it myself more carefully than, just scanning it here in open court. And obviously, I will entertain whatever y'all provide or say, but I'm going to go through each one of these as well, and I'm going to go through the docket. And so if you all want to come back on a date, you all can look over what the defense is requesting, not weeks and weeks from now, but in a couple of weeks, like maybe October 14th, we can come back and see where y'all are at with these things. Does that sound good?
The 14th is fine.
Like sometime that week, not that day, but
I think that would be lovely.
I'm out of the country the 4th to the 14th, but sometime later that week I'll be here, and Mr. Hill and Ms. Day and Mr. Tassoni can handle those issues. What did you say? I'm sorry. And they can handle those issues while I'm gone in terms of getting with the state as to what we think is outstanding and get some idea of when compliance expectations will be reasonable. And then in terms of the court looking and setting deadlines, I believe you had mentioned one of the deadlines is like death penalty motion, right? And I assume that you, maybe wrongly assume, but I assume you were speaking more like the constitutional, more of the generic, let's get those heard, let's get those out of the way, let's get those filed, versus some of the more specific death penalty motions that I just think we may need more time to complete discovery. For example, one involving whether or not the defense believes pecuniary gain should apply. Like, I don't know that that would be ready.
I'm not asking for that. What I am asking for is, whatever, because basically this case, even though we don't know whether it's going to get to that point, we still have to prepare. So I'd like to more that we can get accomplished, hopefully, or at least filed by the end of the year, maybe the constitutional ones, and get those out of the way. Obviously, the ones related to more case-specific or jury selection or any of those, I don't have any problem handling those later on.
Okay.
But the ones that we can handle, I'm at least filed by the end of the year. That would, I think, set us on a better path of like getting everything accomplished. And I don't know if you all thought, you tell me, okay, so the state says that you can, so let's say jury selection takes a week.
And that's the most I've ever set aside. I mean, typically being able to do capital cases, even very complicated ones, in 2 to 3 days. But for this one,
The two defendants,
yeah.
set, two defendants setting, okay. So this is what I have done. It's worked well. We set aside an entire day, not wasting the jurors' time. We could even, I could ask for a special place, but I'm thinking of these things, and you all can, I'm putting it out there. I want you all to discuss them as far as like scheduling wise, that we set aside an entire day, where we sit with as many jurors as we can, going through just specifically any jurors that have cause or hardship because people or have heard about this case in the media. We spend the first day just on that, meaning that we get a usable jury panel that y'all can start questioning. So I would say an entire day would just be what generally takes in a normal jury selection, maybe a few minutes. So the whole day would just be rolling through that many jurors and getting a usable panel so that we don't have people waiting. You see what I mean? Like, so I can give them a report date the following day. If they are able to serve or be questioned, that, and then you all would start potentially your normal questioning.
Is that, do you,
And that worked last year, because I was trying a capital case where I was worried about the holidays, and we were able to do it in the morning, starting questioning in the afternoon, but I'm assuming that you would have morning and afternoon having to go through those number of jurors.
did you do that before the questionnaires?
Yes.
Okay.
So the parties prepared a statement of facts. It's read. I do very short introduction. I go over the trial schedule. Then we use numbers and numbers only, identify those jurors. Those numbers will remain consistent like throughout the process. So if you're seated on either jury, they would just be hypothetically juror number 48 throughout the entire proceeding. So no one had to worry about anyone's names. The jurors all had numbers. When they answered the questions, they held up their numbers so y'all could see it. It worked very well. And it also worked in getting the jury selected, so we weren't questioning people that just couldn't be there. And we didn't hold them, so, So I was thinking, so let's say that whole day is taken up, I would call it like almost the first phase, then the remainder, let's say, so the state says a week.
For jury selection? Yeah.
What about your case?
Our case in chief, the caveat is always like when we're starting, how long we're going. But if we have typically almost full days every one of those days, we will be finished in 4 days.
Right? Did you all discuss that the defendants are entitled to separate penalty phases?
Yes.
They are
Yes.
entitled to present their mitigation separately.
I agree with that.
So, did you all discuss that?
No.
No?
Discuss it? No, not yet, Your Honor.
Okay. So,
Hence why
I would just, so what y'all have proposed, end of October, 1 day off for Veterans
totally agree. This case is moving slow. There's a lot of lawyers that have a lot to say, and I just think the more time we block off, the better.
And certainly as we get, when we're picking the jury, we'll have a much better idea of how long things will take. So my hope is, although we've blocked off that time, that we'll be able to represent to the court that we're able to try this case in a shorter amount of time, and it's smart to block it off.
It's, to me, it's better to block off more time than it is to try to sprinkle around and ask jurors around Thanksgiving to try to get additional time. So whoever is going to commit to serving in this capacity, we basically need to tell them 31 days.
Agreed.
Okay. All right. And we will do that. All of this is tentative, but it helps planning wise. The defense also, for your discussions, for scheduling, I need to know if you all are going to request any type of break in between guilt and potential penalty. If you all are going to be, I need y'all to start thinking about those things so I know how to schedule it. Because scheduling the trial, that period of time, if there's any break, you're into a holiday week. So,
Yes, Your Honor, it's still early, but usually we try to build in a day or two, or Friday or a Monday off, just between the guilt and if we do have that penalty phase, that sometimes there are motions that come up in the middle that we need to address before. So it's kind of building in those two, either a break and or a date just before the penalty starts, or we may have to have some motions so we don't need the jurors there on that day. But at this juncture today, I can't.
no, I'm putting these things out there so that y'all can start talking about them for scheduling. Also, I would not be opposed to, like, on Fridays for everyone's mental health, like maybe doing a half day those days, like before the weekend, since it is such a longer, seeing how we're going, you know what I mean? Like, if on longer cases like that, everyone gets worn out, and so I would be willing to do something along those lines, like a half day on Friday, like you do a morning and then break a little bit earlier on Fridays.
Or at least if the jurors could get that break.
Right.
Yes.
So that's kind of what I'm thinking. That's why in my mind, it's better to do more time than it is less time and try to, like, when individuals come down for jury selection, they don't realize, like, how much it's hard, ever get people to listen for that long. And so I want to build in a little bit of time to be accommodating that way.
And while we're at it, Your Honor, if there's because this is my first time being in your court, if you already have a questionnaire that's approved, if you're able to share that with the two teams, and if we're allowed to propose any additional questions.
It is a very short questionnaire. I can give you a copy of it. I'd be willing to amend it. I can email that to you. It's just biographical information that the jurors do not fill out ahead of time. They come in here, they stand up in front of the lawyers, they read it out, and then the lawyers then get up and start asking questions. But if y'all want to propose certain questions, I can send. I have a longer version and I have a shorter version, depending on. I think in the capital case I used last year, I used a longer version because that defendant was pro se, and I didn't want him. I wanted to give him as much information without him having to ask those questions. So.
Of course we do. I have a proposed questionnaire that I use in cases too, that takes out some things that we asked that typically don't care about.
Okay. So if y'all want to, I can send you, it's very brief.
Yes, if you could send them both, and then if we could just have that opportunity to go through it.
I want to let you know I don't send them out. It doesn't get filled out and they're not in here. They come into court and say it in front of the lawyers, and then everybody kind of like makes a note.
I'll run through with them, make sure.
I'm sorry.
I can talk to the other, I mean, Patrick, and we can fill her in as to how we do it versus maybe other counties.
Okay. All right, did the state, on that motion that the defense filed in the grand jury, do you still have the same position?
State has the same position. There was nothing that we've uncovered that demonstrates a need to pierce the grand jury's privacy.
Okay. Do you want me to table that, Ms. Peoples, or you want to be further any further?
If we could just have that just a short, and then I'll let Patrick come back and address the court on that.
Okay.
Because we're coming, I'm anticipating we'll be back on the 14th or that week.
Yeah,
16th.
later in the week. When?
Wednesday or Thursday, Your Honor, would be preferable for our team.
Ms. Peoples?
State's asking for Thursday, you know? The 17th.
Should be fine, Your Honor.
It's fine, Your Honor.
And
Can we do later in the morning? Is that possible? Let me see the lawyers. All right, so on Mr. Fernandez and Ms. Gardner's cases, working backwards. October 20th, 2025, 9 a.m. jury selection. October 13th, 2025, 9 a.m. final pretrial. October 17th, 2024, 9 a.m. I'm sorry, start that. 10:30 a.m. pretrial. Okay, and that's on both cases. Thank you. All right, so, everyone has the dates?
Yes.
Yes, Your Honor.
Okay, thank you so much.
Before we,
Yeah.
I just wanted to make the record that the defense is, is providing these tentative dates with the caveat that the discovery has been completed in its totality no less than 6 months prior, so that would be April then of 2025. And that at this juncture, the defense has not completed the discovery investigation or completed the potential penalty phase mitigation. So these dates are being proposed with that information, or that's the caveat provided.
Okay. We will do our best, and whatever I need to do, I will do. So, and I'm gonna start with, looking
And I've put in more dates than necessary, Your Honor, but there's a lot of dates in there, just to, with an abundance of caution, put more argument hearing dates in there. So I think we need 2 or 3, but I think I provided maybe 4 or 5.
Okay. All right, thank you all very much, I appreciate it.
I
did
just
have
wanted,
one-
I'm sorry, we jumped right in this afternoon. I just wanted the record to reflect that not only was I here on behalf of Mr. Fernandez, that Frank Cassoni appeared, Attorney Day and Attorney Hill were also here on behalf of Mr. Fernandez.
Yes, thank you very much. I appreciate y'all getting together.
And the ultimate last thing is, in terms of defense motion regarding the timely filing, is there any objection from the state on that?
Yes. I mean, we're not, filing written, absent the court's direction, obviously we'll do what the court says. We're not agreeing to filing a written response to everything the defense files.
When there's an objection, that's the only time we're asking for it. If they're objecting, because what's happening is we'll walk in the day of the hearing, receive case law at that juncture. So we're just asking if there's going to be any case law provided for the court's consideration, that we receive that in advance.
We'll email that, we do our best to make that happen.
Okay, I'll take both under advisement, and Ms. People, you said that Mr. Cray is going to handle the grand jury before
On the 14th, or
17th.
17th, yes, Your Honor, at 10:30, and if not, I will.
Okay, so we'll just take up both motions at that time.